All right, welcome back. Got a fun one today, and by fun, I mean this one is a treat. So, without bearing the lead, we finally have Google's response to delete laws. But before we jump into that, as always, how did we get here? So, this is DeCastro versus Abrams, the Massachusetts case, and as always, we start in the docket. Scroll down, scroll down, scroll down. This is a awfully long docket considering this case is really still right at the beginning. Um, so last time we were here, we had the second supplemental complaint, which was nothing. It was a bunch of URLs saying, well, this is more copyright infringement, even though that didn't say which of them were infringed, which of them, which videos had infringed on them or how they were infringed or anything like that. But that was his second supplemental complaint, which he filed. To his credit, he did ask to file a supplemental complaint, and the judge allowed an amended complaint, and it's a mess. But so that's where we were last time. So since then, yesterday we had a flurry, and we first we had the corporate disclosure from Google, the Rule 7.1 disclosures. Basically, it just says, hey, this is YouTube. We're owned by Google, which is owned by uh, XXVI Holdings Inc., which is owned by Alphabet. Uh, and we don't know of any conflicts. So that's what 119 is. I didn't even open it here because there was no point. So next, 120, we had a motion to appear pro hoc vice. So uh, on the docket, it's motion for leave to appear pro hoc vice for admission of Benjamin D. Margot, who is not licensed in Massachusetts. So before we look at that motion, it's short. Let's look at who Benjamin Margot is. So just like all the other lawyers for Google that we've seen, he is at Wilson Sonsini, which is a absolute tip-top cream of the crop law firm. Just absolutely top tier. I think I mentioned they recently opened a office here in Salt Lake, and the number one attorney in my class had already made partner at the best local firm here in Salt Lake, and he went over to Wilson Sonsini as an associate. So he went from partner to associate, but it was a step up. So it's that type of law firm. And Benjamin Margot is also an associate there in the Internet Strategy and Litigation Division. And I that kind of tickles me. Internet strategy and litigation. This is who our 20-year constitutional law scholar is up against. Internet strategy and litigation. And JD, New York University School of Law, magna cum laude, order of the coif. Now, order of the coif, for those of you who don't know, and why would you unless you're a lawyer? So, lots of law school grads graduate with honors. My school, the University of Utah, doesn't do the cum laude, magna cum laude, summa cum laude. It's honors, high honors, highest honors. Same thing, just not in Latin. I graduated with honors. So this guy, magna cum laude, order of the coif, though, is like the highest honor graduating law school. It's I think top 10%, maybe top 5%. It's very limited. It's like you see order of the coif, you know they were the best law students. It doesn't mean they're the best lawyers, but it means they were the best law students. So just uh and then MA from Georgetown with honors, bachelor's from Harvard with honors, admitted the bar of the District of Columbia, state of California, state of New York, uh, Central District of California Federal Court, Northern District, U.S. District for District of Columbia, Western District of Michigan, SDNY, and Court of Appeals for the First Circuit. So he's very accomplished, very good lawyer, I'm guessing. I don't know if he wrote the motion we're looking at today. He didn't sign it. The already existing attorney, Mr. Gorman, did. And just as a refresher, Mr. Gorman also went to law school at NYU, and his bachelor's was at Cornell. So these are the guys our 20-year constitutional law scholars up against. So let's just take a look. This isn't the most exciting thing we're going to look at today. But it's the motion for admission pro hoc vice of Benjamin D. Margo, pursuant to Massachusetts Local Rule 83.5.3E. Matthew D. Gorman, Esquire, a member in good standing of the Bar of the Commonwealth of Massachusetts and the United States District Court for the District of Massachusetts, moves Benjamin D. Margo be granted to leave to appear in this action pro hoc vice as counsel for defendant Google LLC. In support of this motion, and based on the representations set forth in the attached declaration of Benjamin D. Margo, Exhibit 1, Mr. Gorman states as follows. Benjamin D. Margo is an associate at Wilson Sonsini in New York City. Mr. Margo is a member in good standing of the bars of New York, California, the District of Columbia, and every jurisdiction where he is admitted to practice. There are no disciplinary proceedings pending against Mr. Margo as a member of the bar in any jurisdiction. Mr. Margo previously had a pro hoc vice admission to this court or other admission for a limited purpose under this rule, revoked for misconduct. Mr. Margo has read and agrees to comply with the applicable provisions of the local rules of the United States District Court for the District of Massachusetts. Wherefore, Mr. Gorman respectfully requests that his motion to admit Benjamin D. Margo pro hoc vice be allowed. Respectfully submitted, Matthew D. Gorman on May 23rd, 2023. So, and then I don't have it open. It mentioned Exhibit 1, which is the declaration of Mr. Margo. It basically lays out exactly what's in the motion here. It's signed under penalty of perjury. It's a declaration. So that's pretty much a formality. I wouldn't be surprised if Delete Lawz opposes it just to be an obstructionist, but that doesn't matter because it's a formality. So with that, let's jump into today's main event. event. This is Google LLC's motion and memorandum of reasons to transfer to the Northern District of California, or in the alternative, to dismiss. So remember, pleading in the alternative is you say, Judge, we'd like this or this, but we'd like one of these. And they could be incompatible with each other, but it's please give us one of these. And if they did, if Judge Burroughs dismisses, there will be no point in transferring. Whereas if she transfers to the Northern District of California, that means she's not dismissing. Which of these do I think is more likely? Well, frankly, I think the motion to dismiss is the more likely, because as we've said all along, he hasn't stated a valid claim against Kate or Josh, but he especially hasn't stated one against Google. And so what's the point? Transfer it to immediately dismiss it in California? That there is no point. Except that there is one reason, there's one reason why I think Google is asking for this first. The motion to transfer is listed first above the motion to dismiss. And that is basically Google asserting its terms of service. More specifically, the venue selection clause in the terms of service, which we'll get to it, but it mandates if you sue Google, if you sue YouTube as a user of YouTube, you've agreed to their terms of service, and those terms of service say you've got to sue us in the Northern District of California. So they basically, I think they're trying to assert, yeah, our terms of service are binding. Here's how binding they are. But why don't you just dismiss it too? So this is excellent legal writing once we get into it. I have only looked at a little bit of it. I've saved it for you guys, my reaction, but it's excellent legal writing. And that being said, I'm guessing 80% of it they pulled from their existing database of motions. They didn't write it from scratch. And if you look where my cursor is here at the top left, where the document title is, Microsoft Word, motion to transfer or alternatively to dismiss. And then we have a series of numbers. I'm guessing those series of numbers are Google's attorneys' basically internal notation of which of the forms they plucked this from. I could be wrong, but I'm guessing that's what it is. And basically what they did is they have, they've written so many motions to transfer that they have one for every jurisdiction by now. And basically they have a macro where they go into Word and they enter the plaintiff's name and what little extra information they need and tailor it to the case. That's going to be 80% of this is my guess. For all I know, Mr. Gorman might like writing his motions from scratch, but there's no point usually. especially at this level, and really especially when you're billing Google $800 an hour, probably. So, you know we're serious when there's a table of contents. So we've got the introduction, factual and procedural background, YouTube and its terms of service, DeCastro's claims. Uh, the court should transfer plaintiff's claims against Google to the Northern District of California because the parties agreed to a binding forum selection clause, which requires this case to be litigated in the Northern District of California. The forum selection clause governs plaintiff's claims. YouTube's forum selection clause is enforceable. Plaintiff cannot carry the heavy burden necessary to overcome the forum selection clause. In the alternative, so in other words, as another option for you, Judge, plaintiff's claims against Google should be dismissed. Pleading failures are fatal to plaintiff's amended complaint. Plaintiff licensed his videos to YouTube. Then a conclusion, Rule 7.1A2 certification, certificate of service. So that's our exciting table of contents. And then we have a table of authorities. How many of these have we seen before? Just off the first page, I know that we have discussed Ashcroft versus Iqbal and Bell Atlantic versus Twombly. Those are the basically it's the controlling case law on Rule 8 pleading standards required to survive a 12b6 motion to dismiss for failure to state a claim upon which relief can be granted. You've heard me refer to them mostly as Twombly and Iqbal. But, we have Biltz versus Google, Bowen versus YouTube, Business Casual Holdings versus YouTube. Funny enough, I looked that case up just last week because there's YouTube drama over Business Casual and making false copyright strikes against another YouTube channel again. I almost covered that last week, but got lazy and didn't want to. Let's see. Connect You LLC versus Zuckerberg. I bet it's that Zuckerberg. Delima versus Google. Let's see. Songfi versus Google. Jasper versus Sony Music Entertainment. Kenny versus Warner Brothers. Kiffle or whatever versus YouTube. Kijimoto versus YouTube. Lewis versus Google. MDY Industries versus Blizzard Entertainment. Muhammad versus YouTube. Let's see. Songfi versus Google. Spinelli versus NFL. Trump versus YouTube. So, why do I point out all those cases? The case law with Google, YouTube, Zuckerberg, Warner Music, whatever. It's almost like Google has been through this before. Delete Lawz thinks he's bringing some novel argument to the table. He's not. Google has form responses for his brilliant legal arguments that he thinks he's the first to bring. We all remember, I'm sure, the discussing Lawz videos with delete Lawz, where, well, the fair use, there really isn't any case law on it, so that's just nonsense. There's so much case law, and so much of it has been litigated by Google, by YouTube. So that they're pros at this. This is their business. So and then the statutes, I don't know what most of these are off the top of my head. That I think these 17 USCs are the copyrights, or is it the 28 USCs? Because I know we've covered some of these, but I don't remember off the top of my head. And then we've got the DMCA rules, 12B6, 15A1B, and 21. Ooh, and we've got Black's Law Dictionary, 6th edition. Lawyers do actually use Black's Law Dictionary sometimes, but it's not law, despite what sovereign citizens think, and it's persuasive. It's not controlling. So with that, let's jump right into the introduction. Defendant Google LLC, footnote 1. That's an awfully early footnote. Plaintiff refers in his supplemental complaint to YouTube, Google LLC, which he shortens to YouTube, supplemental complaint, ECF number 79 at 1. For avoidance of doubt, the defendant here is Google LLC, the entity that waived service of summons at plaintiff's request, ECF number 99. Google LLC wholly owns YouTube LLC. See Rule 7.1 disclosure filed herewith. And the entity providing the YouTube service is Google LLC. Exhibit A at 3. So basically, footnote 1 just clarifying the corporate structure a little bit. So defendant Google LLC respectfully submits this motion and memorandum of reasons to transfer the case against Google to the Northern District of California under 28 USC 1404A, or in the alternative, to dismiss the case against Google under Federal Rule of Civil Procedure 12B6. Okay, I knew the 28 US code, that's the 1404 is the venue clause. So it's scrolling back up to look at the statutes they're relying on. The 17 US code is going to be the copyright statutes, and then 28 US code is going to be the venue. Lawyers don't memorize these things. We look things up. So, or in the alternative, to dismiss the case against Google under Rule 12B6. Pro se plaintiff Jose de Castro, in the sole count of his amended complaint, alleges copyright infringement against Google and several other defendants. At least as to Google, the court need not take up plaintiff's glaring pleading failures or the lack of merit in his claims, because plaintiff filed suit in the wrong court. pursuant to the forum selection clause in YouTube's terms of service, TOS or terms, an agreement he plainly entered into as a condition of using Google's YouTube service, plaintiff promised to pursue any federal litigation regarding the service exclusively in the Northern District of California. The Supreme Court has made clear that a valid forum selection clause should be given controlling weight in all but the most exceptional cases, citing Atlantic Marine Construction Company versus United States Court for the Western District of Texas, which is a Supreme Court case from 2013. Now, Google's argument, they've already laid it out. Terms of service. Now, if South Park has taught us anything, it's that you always read the terms of service. You've got to read them. Otherwise, you end up as Steve Jobs's human centipede. Read the terms of service. They're there for a reason. Delete Lawz apparently thinks the terms of service don't apply to him. They do. We'll come back to the terms of service throughout Google's argument. But I wanted to get the human centipede over and done with. An unbroken line of cases have held that YouTube's forum selection clause is valid and enforceable, and have applied it to transfer cases like this one to the party's designated forum, the Northern District of California, CEG Trump v. YouTube from 2021, Kiffel versus YouTube 2021, Muhammad versus YouTube 2021, 2019, Seaman versus YouTube 2019, Songfi versus YouTube 2014. So lest you think forum selection clauses are rare, so going to pull this up on my phone so as not to dox my old boss. So for those of you who watch Merb, I know some of you don't like him, some of you love him. So his video last week where he discussed the guy that was arrested for drunk driving here in Salt Lake. Well, I think Salt Lake County, not Salt Lake City, and alleged that his public defenders conspired against him with the prosecutors to get him violated for not showing up to court. So that kind of hit close to home because that was in the West Jordan District Court. I've been there many times. And, you know, when that first kind of popped off a couple of years ago, I remember Natalie, Lawyer Chick, and Uncivil Law, and a couple of others covering it. But I was clearly doing something else, like listening but not watching the screen. Because if I had, I would have noticed, and Merb had it paused, but one of the few people in the courtroom at that time, he wasn't a public defender, he was just a private defense attorney, so not involved in this drama, but just there for it. For those of you who saw, a great big beardy guy that was my boss, and I worked for him at the time that that drama happened. So, um, and then um, my the defendant in that case, who sued the public defenders, it's just crazy because he was for a short time represented by an attorney who was my constitutional law professor. And then the attorney defending the public defenders was in my law school class. So just it was kind of weird seeing that on Merb's channel. But the reason I bring that up is so just looking on the website for my former boss. Um, the disclaimer on the bottom of the website. I understand that I am contacting a corporation, not an individual, and that if I do business with the law firm, it will be with that corporation, not any individuals. I understand that that the public name, the name on the website, uh, blank blank and associates, is not the legal name of the law firm. Rather, it is blank PC. I also understand that whatever may relate to or arise out of any communication with the law firm, which results in any type of legal action, such must be brought in the 3rd District Court of Utah, West Jordan Department, and that this is mandatory and not permissive. So, my old law firm, right there, front page of the website, forum selection clause saying, you must, if you sue us, you as a former client or as a prospective client, if you sue us, it must be in the 3rd District Court, West Jordan Division, not the Matheson courthouse, the main courthouse, not in Tooele, which is also 3rd District Court, not in Summit County, which is also 3rd District Court. The Paltrow trial was in the 3rd District Court. You must do it in West Jordan, which is the same courthouse that the drama of Merb's video occurred in. So it's forum selection clauses like this are dime a dozen. If you read the terms of service on any app you have on your phone, it's going to have a forum selection clause. Your bank is going to have a forum selection clause. Your everything, your doctor's office is going to have a forum selection clause. So basically, any business that you have done business with is going to have a forum selection clause. So the only way you're going to be able to sue Google outside of the Northern District of California is if Google violates your rights, commits some tort against you, and you're not a user of YouTube. You're not a user of Google for the purposes of that. So if someone else uploads your stuff to Google and to YouTube, and YouTube fails to remove it, to issue a copyright strike, and then you can sue somewhere else, maybe. That court would still have to have jurisdiction over YouTube, over Google. But if it's a dispute over something covered by the terms of service, it's going to be in the Northern District of California. So That's a long enough ramble. Let's get back to it. Even if this case was properly venued here, meaning Boston, plaintiff's claims against Google cannot proceed on its merits. Most obviously, plaintiff has not satisfied a necessary condition to bringing a copyright infringement claim. He nowhere alleges that he registered any of the works that were infringed with the US Copyright Office. That requires immediate dismissal because 17 US Code Section 411A bars a copyright owner from suing for infringement until registration has been made, citing Fourth Estate Publishing Benefit Corp versus wallstreet.com, which is a Supreme Court case from 2019. Now, how many times have we said that here? We've said that many times. You've got you can't like, yes, Delete Lawz owns the copyright to all of his videos, but in order to sue for copyright infringement, you have to have that registered and not just applied for, not just pending. It has to be registered, signed, sealed, delivered, done. He hasn't done that on any of his videos. But that costs money, and he'd have to hold a fundraiser for that, and we know how much he hates doing fundraisers. Oh, wait. And just, I want you to pay attention. How many times is Mr. Gorman or Mr. Yeah, I think it's Mr. Gorman that signed this motion. How many times is Mr. Gorman going to say the exact same things that I have been saying for months now? For months. That Delete Lawz has said, well, no, it's different. That doesn't apply to me. That, no, just the nope defense. But when you consider that Google's argument is virtually identical to what I have been saying and Merb has been saying for months, probably, we might know something. We might know a thing or two. We might, be better at analysis than Delete Lawz gives us credit for. And if Google is wrong, I'll say this is wrong. I don't agree with this. But I don't see myself having to say that. So the court need go no further to dismiss the case, meaning no further than saying, hey, there's no registration. We've got to dismiss. Beyond that, plaintiff's bare bones complaints are little more than threadbare recitals of the elements of a cause of action supported by mere conclusory statements and fall well short of the requirement that they must contain sufficient factual matter accepted as true to state a claim to which relief that is plausible on its face, citing Ashcroft versus Iqbal, Supreme Court 2009, which itself quotes Twombly of the Supreme Court from 2007. Now, is that not exactly the language I used way back in like October when I first brought up Iqbal and Twombly? I think I read this exact quote from the case that you need more than threadbare recitals of the elements of a cause of action supported by more than mere conclusory statements. And you need sufficient factual matter, which, if accepted as true, uh, equate to a state that is plausible on its face, a claim for relief plausible on its face. I think I read that exact section of those cases because, well, that's the holding from the case, so that would be the part I read. But it's true. How many times have I shouted, "That's conclusory. Where's the evidence? There's nothing here." That this is why finally, even if plaintiff managed to make out an infringement claim, the license he granted YouTube and others via YouTube's terms of service clearly covers and bars the claims against Google that he now tries to assert. Meaning, delete Lawz is the human centipede. For all these reasons, this court should transfer this case to the Northern District of California, or, in the alternative, dismiss it for failure to state a claim. Factual and procedural background. A. YouTube and its terms of service. Google LLC, which is with its wholly owned subsidiary YouTube LLC, collectively Google, operates the YouTube service, which allows users to watch and share videos and other content, provides a forum for people to connect, inform, and inspire others across the globe, and acts as a distribution platform for original content creators and advertisers large and small. Declaration of Raquel Small, Declaration Exhibit A at 2, Terms of Service. So we'll look at Ms. Small's declaration after we finish this, but let's look at footnote 2. Materials not attached to the complaint may be consulted if their authenticity is not disputed by the parties, they are central to the plaintiff's claim, or they are sufficiently referred to in the complaint. Schaefer v. IndyMac Mortgage Services, First Circuit, 2013. The TOS governs the relationship between plaintiff and the YouTube service and is thus central to his claim, and its text is publicly available and cannot reasonably be questioned. See the URL for the YouTube terms of service. YouTube allows visitors to access and use its service, including by creating channels and uploading videos free of charge, provided they agree and adhere to the TOS. The terms govern the relationship between YouTube and its users, including plaintiff. Users may post content to their own channels. In order to create a channel and upload content to YouTube, every user is required to accept the TOS. For example, in the current version of the sign-up process, when users create a channel, they are informed that by tapping Create Channel, you agree to YouTube's terms of service. The phrase YouTube's terms of service appears in blue font and links to the complete text of the TOS. By clicking Create Channel, users agree to abide by the TOS. The user cannot activate the channel or post content to the site without accepting the TOS. Certain users are invited to join the YouTube Partner Program, in which YouTube pays them a portion of the revenue attributable to the videos they upload, conditioned on their agreement to the YouTube Partner Program terms. Plaintiff Jose de Castro is a member of the YouTube Partner Program. So am I. And as such, has agreed to the YouTube Partner Program terms in addition to the general terms of service. See also Declaration Exhibit B, YouTube Partner Program terms. Amended complaint. Yeah, I'm not used to seeing that. I'm used to Delete Lawz writing First Amendment amended complaint. FAC. ECF number 62. As a revenue stream, I create video content and publish it on YouTube. Footnote 3. The revenue plaintiff earns from YouTube, pursuant to the YouTube Partner Program terms, allegedly threatened by copyright infringement, is central to plaintiff's claim. Schaefer at 100. The first sentence of the YouTube Partner Program terms states that the YouTube terms of service, which may be updated from time to time, are incorporated herein by reference. That meaning we're not writing it out again, but the main YouTube terms of service also apply to the partner program as our terms of service. The YPP terms further state that the governing law and dispute resolution provisions of the YouTube terms of service will also apply to these terms. So you may remember, I think we've discussed it in the past, how choice of law matters. But basically, for the purposes, if Kate and Josh had brought a slap motion from the start, California's slap law would have probably applied because Delete Lawz as plaintiff is from California. So California law would have been controlling. Now, funny enough, if you have a contractual relationship with a party that you're suing, that contract is generally, at least if it's a good contract, is not only going to have a forum selection clause, it's going to have a choice of laws clause, which, spoiler alert, this one does. The laws of the state of California apply. So, at least as applied to YouTube, to Google, the laws of the state of California apply, period. So the TOS includes and has included at all relevant times an express forum selection clause designating the federal or state courts of Santa Clara County, California, as the required venue for litigation arising out of the YouTube service. This is the version of the provision applicable to all current users. All claims arising out of or relating to these terms or the service will be governed by California law, except California's conflict of laws rules, and will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. You, meaning Delete Lawz in this case, and YouTube consent to the personal jurisdiction in those courts. Meaning, even if Delete Lawz let's say Google were the party suing Delete Lawz. Or scratch that. Let's say Google for some reason sued me. Normally, the federal and state courts in Santa Clara County, California, would have absolutely no jurisdiction over me. But I've agreed to it. I've agreed that if I give YouTube a reason to sue me, the courts in California have jurisdiction over me, even though I'm in Salt Lake City, Utah. So, and just thinking aloud here, I'm pretty sure there's state courts in Santa Clara. Because let me see. Because I'm guessing the federal court. So the Northern District of California is centered in San Francisco, but Silicon Valley, which is Santa Clara, is in Silicon Valley. You might say the heart of Silicon Valley, is also in the Northern District. I'm just looking up. San Jose, as I thought, is in Santa Clara County. So I'm not sure if there's a federal courthouse in Santa Clara. I'm guessing it would be in San Jose. Not that it really matters, because like I said, I think it's going to be dismissed. So service is a defined term in the TOS that encompasses the YouTube platform and the products, services, and features we make available to you as part of the platform. Santa Clara County, California, lies within the Northern District of California. See 28 U.S. Code, Section 84A, footnote 4. Because many millions of users create channels and upload videos on YouTube's website free of charge, the forum selection clause is necessary to manage the costs of litigation and reduce the burden to YouTube that would arise if the company were forced to litigate claims all over the world. So that's just how it is. If you have to defend yourself in 1,000 cases in 1,000 different courts, the costs are just astronomical. Whereas if you have them all in the same 2 courthouses, one state and one federal, your lawyer doesn't have to go from court to court or even courthouse to courthouse. In many cases, it won't even be courtroom to courtroom, because they'll just hear cases back to back to back to back and schedule it like that. It's bing, bang, boom, done. YouTube's terms also provide that users, by uploading video content to the service, grant to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it in connection with the service and YouTube's business. Exhibit A at 8, and also Business Casual Holdings versus YouTube, which, like I said, it's a 2022 case. The appeal in November of 2022 with the Second Circuit, that appeal was denied, if I remember right. If it's not still pending, I believe it was denied. And quoting from Business Casual Holdings, uh, quoting the license provisions of the TOS. Accordingly, any videos that plaintiff uploaded to YouTube, including videos that were allegedly infringed by the other defendants, have been licensed to YouTube pursuant to the TOS that plaintiff agreed upon. De Castro's claims. On September 2nd, 2022, plaintiff Jose Maria de Castro filed his original complaint solely against defendants Kate Peter and Joshua Abrams, the individual defendants, ECF number 1. That complaint asserted claims of defamation, counts 1 and 2, and intentional infliction of emotional distress against the individual defendants, but did not assert any claims against Google or any copyright infringement claims against anyone else. On November 16th, 2022, plaintiff filed his first amended complaint, FAC, replacing the 3 counts of his original complaint with the new count 1, alleging copyright infringement against the individual defendants and unidentified John Does. Plaintiff styles his first amended complaint as a complete pleading in itself with no reference to his original claims, and it was recognized by the court as an amended complaint pursuant to Rule 15A1B of the Federal Rules of Civil Procedure, Electronic Order, ECF number 65. The first amended complaint thus supersedes the antecedent complaint, replacing the original complaint lock, stock, and barrel. Connect You LLC versus Zuckerberg, First Circuit, 2008. On December 2nd, 2022, plaintiff filed a supplemental complaint adding Google to the case, caption, as a defendant for the first time. It does not list any counts against Google or include a prayer for relief against Google, but the factual background section alleges that upon receiving notices of copyright infringement by plaintiff under 17 U.S. Code Section 512C3, YouTube failed to take down infringing content on its service, having determined on multiple occasions that the purportedly infringing content is exempt from takedown under the Digital Millennium Copyright Act due to copyright fair use. Quoting from the supplemental complaint. See also 17 U.S. Code Section 512, DMCA Safe Harbor Provision. Although he attaches a list of URLs supposedly constituting his works, he does not allege that any of them have been registered with the Copyright Office. Plaintiff also does not identify which specific videos were infringed, where on YouTube those works were infringed, which, if any, of those infringements became the subject of notices to YouTube, or any other supporting facts explaining the nature of the infringement. Plaintiff wrongly asserts the legal conclusion that YouTube's inaction was in violation of the DMCA and its standard technical measures because he notified YouTube he had filed a court action. Wow. Do you guys remember me saying that exact same thing? Saying he has not stated a claim upon which relief can be granted because he's just given us URLs. He said, they infringed my work. He didn't say, this video infringed on my copyright of this video because it's, you know, we've mentioned South Park already, the human centipad. This is the underpants gnome. Step 1, underwear. Step 2, question mark. Step 3, profit. It's step 1, my video. Step 2, question mark. Step 3, infringement. It doesn't work like that. And, you know, like I said, he has been corrected many times, and he knows he's been corrected because he discussed it with discussing Lawz. That is not how the DMCA works. You don't get to copyright claim someone and then say, I'm suing. Well, and you can't sue Kate and Josh for copyright infringement and then say, well, I have a copyright case going, so that means you've got to take down any other video from any other user because I'm in litigation. And that's what the requirement of the DMCA is. We told him many, many, many times, no, it's not. But he insisted he knew better. He doesn't. On April 24th, 2023, plaintiff filed a second supplemental complaint. The second supplemental complaint adds no allegations concerning conduct by YouTube or by Kate and Josh, saying only that since the filing of the first amended complaint and the supplemental complaint, all defendants, including unknown ones, have committed additional copyright and DMCA violations against plaintiff. This time, he includes a list of URLs where his supposed works were infringed, but he does not specify which URLs infringed which original works or provide any other details explaining the nature of the infringement. And once again, he fails to allege that any of these URLs infringed upon copyrighted works that he has registered with the U.S. Copyright Office. He's stuck in step 2 of the underpants gnome. Question mark. And like I said, you'll notice Google is making the exact same arguments that I have made, that Merb has made, that Kate has made, that Josh has made. I'm sure I don't watch Josh's videos because, frankly, I find him awful too. But, you know, in this case, he's right. So I'm rooting for him to win against Delete Lawz because Delete Lawz is wrong. But like I said, just because Google is arguing this doesn't mean Google's right. But like I said, they've made this argument so many times in so many other cases, and they have won. So if they were wrong in previous cases, they'd have stopped making that argument by now. They'd have changed their argument. They'd have changed their terms of service. They'd have changed YouTube, period. But since Google's argument is right, thus my argument is right, thus Delete Law's argument is wrong, here we are. In sum, none of plaintiff's complaints identify any allegedly copyrighted works he actually owns and registered, except to vaguely assert the existence of over 800 videos, all of which he allegedly published to his YouTube channel at the URL, and thus licensed to YouTube pursuant to the TOS. And despite having filed 4 complaints to date, he still has not identified which specific videos posted by which specific defendants infringed which specific works. I'm going to repeat that because Mr. Gorman just said exactly what I said. Like I said, this is my first time reading this. I had not read that sentence yet, but rewind and you'll hear me say almost word for word that exact same thing, but not reading it. Despite having filed 4 complaints to date, he still has not identified which specific videos posted by which specific defendants infringed which specific works, let alone the nature of that infringement or whether those infringements concern any works registered with the Copyright Office. I didn't even, the first time I didn't even get through that second part of the sentence. The nature of that infringement. That's the how. Like I said, which video infringed on which of his videos and how did it infringe? The nature of that infringement. It's almost like I'm speaking the same language as Google. Section 3. The court should transfer plaintiff's claims against Google to the Northern District of California. The parties agreed to a binding forum selection clause, which requires this case to be litigated in the Northern District of California. When the parties have agreed to a valid forum selection clause, a district court should ordinarily transfer the case to the forum specified in that clause, citing Atlantic Marine from the Supreme Court, and 28 U.S. Code Section 1404, permitting transfer to any district to which all parties have consented, which, as we know from the Human Centipede Agreement, TOS, Delete Lawz has agreed. Only under extraordinary circumstances unrelated to the convenience of the parties should a Section 1404A motion be denied. So it can't be Delete Lawz saying it's more convenient for me to litigate it in Massachusetts. He can't say it's more convenient for me to litigate in conjunction with litigating against Kate and Josh. Because I saw in the Masshole Discord, someone asked, well, what happens if it is transferred to California? Does that mean Kate and Josh are dragged to California? No. It means the case is severed and it becomes 2 cases. Kate and Josh keep litigating in California and Delete Lawz, or in Massachusetts, and Delete Lawz and Google in Boston, or in, I can't speak today, apparently, in California. And hang on. Hang on. Cura v. Synergy Compute. Okay. You'll notice in it cites only under extraordinary circumstances unrelated to the convenience of the parties should this motion be denied, citing the same id from above. which quotes other cases, and one of them that has in parentheses Burroughs, comma J. Did Judge Burroughs decide one of those cases? Let's see. Let's see. Looking it up on my phone because it's faster sometimes. Except when I want it to be fast, then it's slow. Come on, phone. Judge Burroughs. Hey, it's almost like she's heard forum selection clause litigation before. Ha! I like that friendly reminder from Google. That just, yeah. And it also quotes Atlantic Marine, Europa Eyewear versus Kaizen. And then after Atlantic Marine, in the vast majority of cases when a forum selection clause is included, a Section 1404A motion to transfer will be allowed. Quoting Keb Management versus Home Depot USA, District of Massachusetts, 2014. Because a forum selection clause represents the parties' agreement as to the most proper forum, the presence of such a clause requires that certain adjustments be made to the regular Section 1404A analysis, Atlantic Marine. As relevant here, these adjustments dictate that the plaintiff's choice of forum merits no weight. The district court should not consider arguments about the parties' private interests, and only public interest factors can be considered. However, those factors will rarely defeat a transfer motion, citing Reynoso v. Lasership, District of Massachusetts, 2018, which also quotes Atlantic Marine. So basically, unless there's a public good reason to keep it in Massachusetts, it's not staying in Massachusetts. And even if there's a public interest reason to keep it in Massachusetts, those rarely defeat a transfer motion. So further, the plaintiff bears the burden of showing why the court should not transfer the case to the forum to which the parties agreed. Still citing Atlantic Marine. See also Carnival Cruise Lines versus Shoot, Supreme Court, 1991. A party seeking to avoid a forum selection clause bears a heavy burden of proof. So that means that this is basically a rebuttable presumption. So this isn't Google has to convince the court to transfer it. It's Lawz has to convince the court not to transfer it. Applying these principles, courts in this district routinely enforce forum selection clauses. C.e.g. Servant versus CRST International, District of Massachusetts, 2020. Fireman's Insurance Co. versus ACE, District of Massachusetts, 2019. Power Products Sales and Service versus Hydrotite, 2019. And Keb Management, which we've seen above. The same result is required here. Plaintiff's claims are governed by a binding forum selection clause. That provision requires that this litigation proceed in the Northern District of California, and no extraordinary circumstances preclude a transfer to the party's designated federal forum. The forum selection clause governs plaintiff's claims. Plaintiff is a YouTube user for now, and in creating his channel, he affirmatively agreed to YouTube's TOS, including its forum selection clause. The broad language of the forum selection clause readily encompasses plaintiff's claim that YouTube failed to take down infringing content on their service and determined on multiple occasions that content is exempt from takedown under DMCA due to copyright fair use. The governing forum selection clause applies to all claims arising out of or relating to these terms of service. As noted above, the term service is expressly defined as the YouTube platform and the products, services, and features we make available to users. The phrase relating to is interpreted broadly and means simply connected by reason of an established or discoverable relation, citing Huffington v. TC Group, First Circuit, 2011. See also Peak v. Tigergraph, 2021, District of Massachusetts, ruling the same. Transferring a case based on forum selection clause covering any disputes arising out of, related to, or in any way connected with the relationship between the parties. Keb Management, see also Keb Management. The forum selection provisions cover any disputes relating to or in connection with the MSA. Those provisions are generally construed quite broadly. I get lost in those citation strings. I forget. Wait, am I in a C also, or am I in a new quote? It just, I don't like some of the legal citation rules. It is clear that the amended complaint and the supplemental complaint that plaintiff's claims against Google fall within the clause's broad scope. The claims arise from the alleged copying of plaintiff's videos from YouTube, the individual defendants allegedly uploading unspecified infringing videos to YouTube, and Google's alleged decision not to take down those videos from YouTube. Though the claims are not cognizable under the Copyright Act, they indisputably arise out of or relate to the YouTube service. Claims challenging YouTube's decisions about taking down infringing content on their service clearly arise from and relate to the service. See, e.g., Kiffle versus YouTube, Northern District of Georgia, 2021, holding that plaintiff's copyright infringement claims were within the scope of YouTube's forum selection clause, where plaintiff had uploaded those videos to YouTube. Also, Kijimoto versus YouTube, Central District of California, that's Fresno is Central District. Sacramento might also be. But Central District of California, 2018, enforcing YouTube's forum selection clause is in a copyright action. Footnote 5, plaintiff also complains incorrectly that Google is in violation of the DMCA, specifically 17 U.S. Code Section 512I. See Supplemental Complaint 1, paragraphs 11 and 13 through 15. This is not a count of the complaint, nor could it be, because alleged failures to satisfy the conditions of the DMCA safe harbor provision cannot constitute a cause of action without a viable underlying claim for copyright infringement. Business Casual Holdings, 2022. But if it was, it would certainly arise out of or relate to the YouTube service. So basically, it's saying, look, if you haven't even proven that someone has violated your copyright, you can't prove that we have violated the DMCA safe harbor of the copyright laws. Because how can we be in violation of the DMCA if you haven't proven that we have to comply with this aspect of the copyright law that you haven't proven? It just doesn't make sense. And YouTube's forum selection clause is enforceable. A forum selection clause is prima facie valid, and absent a strong showing by the resisting party that the clause is unreasonable under the circumstances, it should not be set aside, citing Claudio de Leon versus Sistema Universitario Ana G. Mendez, First Circuit, 2014, which itself quotes MS Bremen versus Zapata Offshore Supreme Court case from 72. See also Peak and also Cura, which cites Rivera v. Centro Medico de Turabo in the First Circuit in 2009. Courts have consistently held that forum selection clauses in standard forum online agreements, like the YouTube TOS that plaintiff expressly accepted, are valid and enforceable. See e.g. CR Associates LP versus Sparefoot, District of Massachusetts, 2018, which enforced a forum selection clause and observed that there is nothing unconscionable or unfair about the provision here, where Sparefoot requires each new client to agree to terms of use online. YouTube's forum selection clause, in particular, has repeatedly been applied. Every federal court that has considered a motion to transfer, or that has considered a transfer motion based on YouTube's TOS has enforced the clause, finding no procedural or substantive issues with its requirement that litigation relating to YouTube's service or TOS proceed in the Northern District of California, CEG Songfi, which states, it is not improper for YouTube to require that claims against it be brought in the non-arbitrary forum where it resides. So that says, hey, this isn't even arbitrary. YouTube is headquartered in Silicon Valley, in Santa Clara County. So it makes sense. It's not arbitrary to say, hey, you've got to sue us where we're located. And yeah, they're incorporated in Delaware, I believe, but so saying you've got to sue us in Delaware also wouldn't be arbitrary. But even choosing Santa Clara over Delaware isn't arbitrary, because Google's legal department is in Santa Clara. Whereas if they said, you've got to sue us in Marfa, Texas. Now, that would probably be arbitrary, because I highly doubt that they have anyone there in Marfa, Texas. And before Zoom Court, well, getting to Marfa, Texas is, incentive enough not to sue there. So it's probably arbitrary. It's probably onerous. But even that doesn't necessarily defeat that forum selection clause. But having Santa Clara, California, that just makes it all the stronger forum selection clause than if it had been Marfa, Texas, or Fargo, North Dakota, or Timbuktu, or whatever. And that they could say, you must sue us in London using California substantive law. In fact, that's probably what their terms of service for English users say. Well, if it doesn't say you must sue us in California still, but it's going to say, this is where you sue us if you're a European user, whether it's, London, Paris, Frankfurt, Santa Clara, under California law and European Union law as applicable, because, the EU does have very strong privacy laws that are going to apply, even if the terms of service don't. And in fact, that they're just going to have that written into the European terms of service, because that's just how it is. Otherwise, they don't operate in Europe. And continuing, quoting from Kiffel, transferring a case brought by YouTube user despite plaintiff pointing to evidence that California will be less convenient forum for him. So, tough luck. You agreed to the terms of service. Therefore, you sue where Google says you sue. It doesn't matter if it's less convenient for you. Besides, Delete Lawz is ostensibly a California resident. And then Lewis v. Google from the District of Colorado in 2019, plaintiff has failed to cast any doubt on the validity of the forum selection clause, and so the Atlantic Marine analysis applies here. And then also Romani versus YouTube from the SDNY in 2019. The court concludes that YouTube's forum selection clause controls and transfers the action to the United States District Court for the Northern District of California. And then Muhammad, where they find no evidence or jurisprudence to show that the forum selection clause was induced by fraud or overreaching. And then Biltz versus Google, the District of Hawaii in 2018, finding no fraud or overreaching. Kijimoto, holding that the forum selection clause of the TOS is controlling. Bowen v. YouTube, Western District of Washington, 2008. The court concludes that the forum selection clause herein is valid and enforceable. So we've seen 14 years of case law saying, yeah, you've got to sue Google in the Northern District of California from all over the country. That unbroken line of cases reflects the mandatory nature of the forum selection provision, which states that covered claims will be litigated exclusively in the federal or state courts of Santa Clara, California, Santa Clara County, California. And it's got to say federal or state courts, because if diversity jurisdiction doesn't exist, so if someone lives in Santa Clara, California, well, then they've got to sue in state court, because they wouldn't have complete diversity for diversity jurisdiction unless it's federal questions. So if it is a legitimate copyright claim, then they can sue in federal court because it's a federal question. And then CEG Bowen, which explains that YouTube's clause is cast in mandatory terms. Remember when I read my old law firms? This is not permissive. This is mandatory. And then DeLima versus YouTube, District of New Hampshire, 2021. Any future claim arising out of the AdSense or similar agreement for Google-owned services, however, must be brought in the Northern District of California as a result of the presumptively enforceable and mandatory forum selection clause in that agreement and Google and YouTube's general terms of service. The choice of the word will, a word commonly having the mandatory sense of shall or must, demonstrates the party's exclusive commitment to the named forums. Quoting Summit Packaging Systems, Inc. versus Kenyon and Kenyon, First Circuit 2001, which quotes Black's Law Dictionary 1102, 6th edition, 1991. And also Barcletta Heavy Division versus Erie Interstate Contractors, which in itself quoted Summit Packaging. So, shall or must. It's mandatory, not permissive. Plaintiff cannot carry the heavy burden necessary to overcome the forum selection clause. To prevent the transfer of a case like this one involving a valid forum selection clause, plaintiff would need to bear the burden of showing that public interest factors overwhelmingly disfavor a transfer, citing Atlantic Marine. He cannot do so. This is not among the rare circumstances where public interest factors can defeat a transfer motion. Nor can plaintiff invoke his private interests to keep his claims in this district. When parties agree to a forum selection clause, they waive the right to challenge the pre-selected forum as inconvenient or less convenient for themselves or their witnesses, or for their pursuit of the litigation. A court accordingly must deem the private interest factors to weigh heavily or to weigh entirely in favor of the pre-selected forum. Sometimes I read sort of like autofill instead of actually reading. I just predict the text. That time I predicted wrong. I said heavily, it read entirely. In short, under the clear terms of the governing agreement, the parties agreed to resolve claims like these in a different forum. By filing in this court, plaintiff disregarded that agreement, and so a transfer is required. Footnote 6. Under Section 1404A, the court has discretion to transfer the entire case, including the claims against the individual defendants, who also agreed to the same forum selection clause when allegedly posting infringements on YouTube. CEG answer and counterclaims of Joshua Abrams, ECF number 53, admitting to having YouTube channels. Answer and counterclaims of Kate Peter, ECF number 54, admitting to having a YouTube channel. Users must agree to TOS to create a YouTube channel. The court could also exercise its discretion to sever plaintiff's claims against Google under Federal Rule of Civil Procedure 21 and transfer only those claims. CEG in Re Rolls-Royce Corp., Fifth Circuit 2014, granting mandamus petition to require district court to sever and transfer claims. In Re How Medica Osteonics Corp., Third Circuit 2017, ruled the same. Valspar Corp. Versus DuPont, District of Minnesota, and then affirmed in the Third Circuit in 2017. If the court were to conclude the pertinent factors render transfer appropriate under Section 1404A, then severance too would be proper. And like I said, I expect, number one, I expect the claims against Google to just be dismissed because they're frivolous and no claim is stated. But barring that, I would expect severance. So, in the alternative, plaintiffs' claims against Google should be dismissed. Plaintiffs' claims against Google fail as a matter of law, come nowhere close to meeting pleading standards, and thus should be dismissed on the merits. I agree. It's not a close call. There is absolutely no claim stated. I've had farts that have come closer to stating a claim upon which relief can be granted. Yeah, like I said, I think the reason why they pled transfer first and then dismissal, even though let's face it, Google wants this dismissed more than they want it transferred. We want it dismissed. It's most likely going to be dismissed. But like I said, I think the reason is that they pled that first and then dismissal in the alternative is because they have a vested interest in protecting and defending their terms of service, including the forum selection clause in the terms of service. They don't want to be seen as ever waiving their terms of service, even if they can just get it dismissed real quick. They always are going to defend their terms of service because it's important. If a court at some point were to say, well, you don't seem to treat this as mandatory, you only move to transfer about half the cases, so how is that mandatory if you're clearly happy to fight cases elsewhere? They don't want to ever be put in that position, so they are going to fight it every time, even if they know that the alternative is the result that they're going to get. Pleading failures are fatal to plaintiff's amended complaint. The most obvious deficiency in plaintiff's claims is his failure to allege that any, in bold italics, any of his allegedly infringed works were registered with the Copyright Office before he filed suit, which alone requires dismissal. The Copyright Act and recent Supreme Court precedent leave no doubt that no action for infringement of the copyright in any United States work shall be instituted until registration of the copyright claim has been made in accordance with this title. 17 U.S. Code Section 411A and Fourth Estate Publishing Bencorp versus I think this has been cited before, so I don't know who it's by versus, but it's a Supreme Court case which says outside of statutory exceptions, not applicable here, Section 411A bars a copyright owner from suing for infringement until registration has been made. Where a plaintiff did not register her copyright before filing suit, dismissal of the suit under Fourth Estate is proper, citing Moss v. Marvick, First Circuit 2021. This pre-registration requirement is a bright line rule, and the burden is on plaintiff to satisfy it. It is not surprising that the First Circuit has held that where a copyright complaint did not allege that the registration had been obtained prior to suit, the complaint should be dismissed for lack of sufficiency of the complaint, citing Cortez Ramos versus Martin Morales, First Circuit 2020. The court need go no further. This alone warrants dismissal. But there is more. I like how I was going to say that exact thing. But there's more. But they said it for me. So plaintiff's bare bones complaints come nowhere close to alleging plausible facts that give rise to an inference that infringement occurred. See Iqbal. To state a claim for copyright infringement, plaintiff must plausibly allege the ownership of a valid copyright and copying of constituent elements of the work that are original, citing Kenny v. Warner Brothers and Entertainment, District of Massachusetts, 2019, which itself quoted Feist Publications versus Rural Telephone Service, which was a Supreme Court case from 1991. To establish the second of those elements, plaintiff must allege that the copying of the copyrighted material was so extensive that it rendered the infringing and copyrighted works substantially similar. Which quotes, so that's also from Kenny versus Warner Brothers, which quotes Johnson versus Gordon, First Circuit Court case from 2005. And we've said the same thing. It's clearly fair use because Delete Lawz, his market is criticizing cops, First Amendment auditing. It's a different market. Kate specifically is in a different market, but even though Josh is also a First Amendment auditor, the videos he made are not a market substitute. It's making fun of Delete Lawz. That is the market for those allegedly infringing videos. It's commentary and criticism of those videos. It's a different market completely. It's transformative because they're adding their commentary. Yet, as detailed above, plaintiff alleges nothing about the particular works being copied or the nature of the supposed copying beyond. That's clearly a copy paste error, I'm assuming, beyond broad conclusory statements that reveal nothing of substance. Once again, how many times have I said that's conclusory? That's Delete Lawz coming to a conclusion that isn't supported. It's him saying this is copyright infringement without telling us how it's copyright infringement is conclusory. See First Amendment complaint, paragraph 4. Defendants publish content to YouTube that largely only copies my content. That's conclusory. Paragraph 15. Defendant YouTube publishers have copied large portions of my copyrighted content on their YouTube channels. This is nowhere near enough to survive a motion to dismiss. See TR Safe Pay versus Dynamic Diet, District of Massachusetts, 2018, which dismissed a complaint where plaintiff fails to make a prima facie showing of direct copyright infringement by defendants. It is unclear whether plaintiff has satisfied the pre-registration requirement. Plaintiff has not identified adequately the protected material or defendant's infringement of it, and the court is unable to determine whether there is substantial similarity between the parties' materials. But also, plaintiff licensed his videos to YouTube. Plaintiff's infringement claims against Google fail also because the only videos he claims were copied were videos that he had previously uploaded to YouTube and thus had already been licensed to YouTube. It is a hallmark principle of copyright law that licensors may not sue their licensees for copyright infringement. Jasper versus Sony Music, SDNY 2015. And also a state of Hevia versus Portrio Corp from the First Circuit in 2010, which held that the use of copyrighted work within the bounds of a license is non-infringing. A copyright owner waives the right to sue for uses of copyrighted material that are authorized by a non-exclusive license, citing Great Minds versus FedEx Office and Print Services, Second Circuit 2018, which quotes MDY Industries versus Blizzard, Ninth Circuit 2010. A defendant may raise a complete defense to a copyright infringement claim by presenting the court with the license or sublicense on a motion to dismiss, citing Spinelli versus NFL, SDNY 2015. When presented with such a license that covers the allegedly infringing activity, courts consistently dismiss claims of copyright infringement. CEG Nadav versus Beardwood, SDNY 2018, which dismissed a copyright claim on the basis of an applicable license. Spinelli, which did the same. Atlantis Infotech versus CA Inc., Eastern District of New York in 2007, which did the same. Ariel UK Limited versus Reuters Group, SDNY 2006, affirmed in the Second Circuit in 2008, which held the same. Jasper, which held the same. And Great Minds, which also affirmed a dismissal on the same grounds. In creating his channel and posting content to YouTube free of charge, plaintiff accepted YouTube's terms of service and reaffirmed his acceptance when he joined the YouTube Partner Program to monetize those videos. In so doing, he agreed to a provision described above titled License to YouTube. By providing content to the service, the user grants to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it in connection with the service and YouTube's business. The license is broad, and under the plain language of the license, YouTube cannot be liable for directly infringing any copyrights associated with any content that plaintiff has uploaded to its channel, citing Business Casual Holdings, which dismissed an infringement claim against Google and YouTube based on the same license from YouTube's TOS. This, by itself, disposes of plaintiff's infringement claims against Google. Frankly, against Kate and Josh as well. Footnote 7. Plaintiff's complaints do not say whether he is attempting to state a claim against Google for direct or secondary copyright infringement. Google reserves the right to advance additional arguments if plaintiff is granted leave to clarify his claims in another amended complaint. But remember, Judge Burroughs said, this is pretty much your last bite at the apple. You're not, you're not getting any more amendments unless it's for a really good reason. He has no good reason. Conclusion. Wherefore, Google respectfully asks the court to grant its motion and transfer the case as against Google to the Northern District of California, or, in the alternative, to dismiss the case as against Google with prejudice. Respectfully submitted by Google, or Google LLC by its attorneys, Benjamin Margot Prohak Vichy pending, and signed by Matthew D. Gorman on May 23rd, 2023. And then we have the local rule 7.1A2 certification. Undersigned counsel certifies that counsel for defendant Google LLC conferred with pro se plaintiff Jose de Castro and counsel for defendants Joshua Abrams and Kate Peter in good faith to narrow or resolve the issues raised through this motion, but could not avoid motion practice. Plaintiff opposes Google's motion to transfer and its motion to dismiss. Defendant Abrams assents to the transfer motion regarding the transfer of claims against Google only. To the extent the court is inclined to transfer any other claims, Mr. Abrams requests the opportunity to put his position in writing. Google understands that defendant Peter similarly opposes Google's motion to transfer to the extent that claims involving Ms. Peter would be transferred. Now, remember, these declarations have been waived between Delete Lawz and Kate and Josh because Delete Lawz doesn't behave and has made threats against Benjamin Wish. And so Judge Burroughs basically said, yeah, you don't have to talk to each other. She hasn't made such a ruling with Google. And even if she had, I don't know if Google is, if Mr. Gorman knows about such a ruling yet or would be worried about it, at least at this point. Then it was filed, blah, blah, blah. So that's that. But we still have a little more to go. If it would like to switch tabs for me. So this is the declaration of Raquel Small in support of defendant Google LLC's motion and memorandum of reasons to transfer to the Northern District of California, or in the alternative, to dismiss. So, declaration. I, Raquel Small, to date, do state and declare as follows. I am a program manager on the YouTube legal team. As part of my role, I have personal knowledge of YouTube's terms of service, including the facts described below, and if called as a witness, could and would testify competently thereto. So basically, her declaration is to get the terms of service admitted as evidence for the purposes of this motion. YouTube offers an online video service where users around the world can share and watch videos and related content. With limited exceptions, YouTube is a free service and does not charge users to upload or view videos. Use of YouTube's services is governed by the written terms of service, agreement, TOS, or terms. A true and accurate copy of the current TOS is attached hereto as Exhibit A. The TOS are also available at this link on the sidebar of the YouTube homepage at another link, or elsewhere throughout the YouTube website. The YouTube's terms of service have been modified from time to time over the years. The current version of the TOS and all past versions of the TOS going back to February 2009 require that disputes between YouTube and its users arising out of their use of YouTube be litigated solely in Santa Clara County, California. The current version of the terms provide as follows. All claims arising out of or relating to these terms of or the service will be governed by California law, except California's conflict of laws rules, and will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. You and YouTube consent to this exact language was included in the previous 3 versions of the TOS and has been effective from December 10th, 2019 to the present. And you'll notice all claims arising will be governed by California law, except California's conflict of laws rules. Meaning, usually California might say, hey, well, under California's conflict of laws rules, we should be hearing this under the Massachusetts laws. But the terms of service, they say, no, California laws apply except the California choice of laws law, because terms of service, not California law, but terms of service apply for choice of law. So that they even carve that out in the terms of service. You know, it's the belt and suspenders. They don't want someone to get out of the choice of law provisions by saying, yeah, but you chose California law, and California law says Massachusetts law should apply. Not according to terms of service. Because many millions of users from around the world use YouTube free of charge each day, the forum selection clause is necessary to manage the costs of litigation and reduce the burden to YouTube of litigating all over the world. The current version of the TOS and all past versions of the TOS provide that YouTube may modify the terms over time. Modifications to the terms only apply going forward. The current version of the terms provides as follows. We may modify this agreement, for example, to reflect changes to our service or for legal, regulatory, or security reasons. YouTube will provide reasonable advance notice of any material modifications to this agreement and the opportunity to review them, except that modifications addressing newly available features of the service or modifications made for legal reasons may be effective immediately without notice. Modifications to this agreement will only apply going forward. If you do not agree to the modified terms, you should remove any content you have uploaded and discontinue your use of the service. Users are able to post content to their own channels. In order to create a YouTube channel, users are required to accept the TOS. Currently, users are informed that by tapping Create Channel, you agree to YouTube's terms of service. The words YouTube's terms of service appear in blue font and include a hyperlink to the TOS. Below, there is a blue button labeled Create Channel. By clicking Create Channel, users agree to abide by the TOS. In addition, at all times relevant to plaintiff's allegations, each time a user uploaded a video to YouTube from a desktop web browser, that user was required to click a button reaffirming their acceptance of and agreement to be bound by the TOS before the video would be posted to YouTube. Based on a review of YouTube's records pertaining to the channels created and videos uploaded by Jose de Castro, the plaintiff in Jose Maria de Castro versus Joshua Abrams et al., he created a YouTube channel on July 28, 2020. YouTube's records reflect that in doing so, he affirmatively clicked a button indicating his acceptance of and agreement to be bound by the TOS, which included his agreement to the pertinent forum selection clause. YouTube's records further reflect that Jose de Castro is a participant in the YouTube Partner Program, which provides for YouTube to pay him a portion of the revenue attributable to the videos he uploads to YouTube, conditioned on his agreement to the YouTube Partner Program terms. When he joined the program, he agreed to the YouTube Partner Program terms, a true and correct copy of which is attached as Exhibit B. they state in part that the YouTube terms of service, which may be updated from time to time and are incorporated herein by reference, applies to your participation within the YouTube Partner Program. Exhibit B at 1. They further state that the governing law and dispute resolution provisions of the YouTube terms of service will also apply to these terms. Id at 2. I declare under penalty of perjury that the foregoing is true and correct, and that this declaration was executed on May 22nd, 2023 in San Leandro, California. Signed, Raquel Small. And it's a declaration, but not an affidavit, so it is sworn to and signed, but not notarized. And I've got the certificate of service. So we're almost done, I promise. Clicking on Exhibit A. And this is page 16 of 17 of Exhibit A, the YouTube General Terms of Service. Governing law. All claims arising out of or relating to these terms or the service will be governed by California law, except California's conflict of laws rules, and will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. You and YouTube consent to personal jurisdiction in those courts. And then right above that, we see interpretation of the terms include or including no waiver. If you fail to comply with this agreement and we do not take immediate action, this does not mean that we are giving up any rights that we may have, such as the right to take action in the future. So, you know how I said Google, the reason they're asking for transfer and then dismissal in the alternative. They don't want to be seen as ever waiving it. But they even say, well, even if we aren't, we still haven't waived it. It's in the terms of service. But they don't want a court to say, yeah, but really, we think you waived it. So that they're not going to F around and find out. They're just not going to waive, period. And then I find this interesting, even though I don't think it actually applies here, but limitation on legal action. You and YouTube agree that any cause of action arising out of or related to the services must commence within 1 year after the cause of action accrues. Otherwise, such cause of action is permanently barred. Now, I don't know off the top of my head what the statute of limitations is for a copyright action. But contractually, it's 1 year if it's against Google. It's in the terms of service. They set their own statute of limitations. Now, this is probably easier to get around than the mandatory forum selection clause and choice of laws, but you're still going to have a hard time. That there might be tolling, has the statute of limitations told, because like for lots of things, the statute of limitations doesn't start at the time that the wrong was committed, but at the time it was discovered. So, like, if you come into my house and you steal my tent just randomly, which I'm not going to find out about it until I try to go camping next time. So I might find it next week. I might find it 2 years from now. Well, the statute of limitations doesn't start, presumably, until I find that it's been stolen. It might not even start until I find out that you are the one that stole it from me. So it's not from the time you stole a tent, but from the time either I find out it was stolen or that you specifically stole it. But that's irrelevant here because all the videos are well within a year of him bringing action. And at least I think. Either way, um, finally, we have the YouTube Partner Program Terms of Service. Number 5, governing law. The governing law and dispute resolution provisions of the YouTube Terms of Service will also apply to these terms. So that's pretty much it. So that being said, I'm surprised I got through all that in 2 hours and 5 minutes, especially considering I had a couple of long tangents. So, what are the plans going forward? So, tomorrow, because I'm a glutton for punishment, and apparently it was actually filed, I've got to go over Floyd Wallace's case against the Las Vegas Metropolitan Police Department. That's News Now Omaha. I can't remember what the late great Schrodinger's cat called him because I'm pretty sure he had a nickname for him. I tend to think of him as News Now Future Statistic or News Now Itchy Back or News Now Passport Bro. But I'll look into that. And then I meant to bring this up at the start. So Deborah Rogers, DUI Debbie, had her trial yesterday, I think. She was found guilty on all charges. 15 days. The jury assessed penalties of 15 days and $1,000 fine on count 1, 15 days and $1,000 fine on count 2, and a $500 fine on count 3. That's what the jury assigned, which frankly is strange to me. Most jurisdictions don't do that. The only punishment a jury would decide in most jurisdictions is death penalty or no death penalty. Although News Now Houston, which I'm not going to mention Schrodinger's nickname for him, it violates YouTube's terms of service, talking about that, gets videos demonetized. He was able to choose to have the jury decide his punishment. Was in the case that gave rise to Schrodinger giving him the nickname. But yeah, so I'm assuming, but I could be wrong, I don't practice in the Cherokee Nation courts, that the judge, even though the jury gave its sentencing recommendations, the judge still has to pronounce sentence, which I don't know if that's happened or not. And it could very well be that since she served like 50 days, I don't know if this 30 days or 15 days, if it's consecutive or concurrent. She very well could just pay a fine and be done because she served a lot. Personally, I think, well, you look at it. Yeah, she served those days for contempt, but that's still more than what the jury gave her, whether it's consecutive or concurrent. So I said from the start, I can't see a judge giving her more time than what she's already served. And frankly, if she had cooperated from the start, not gone to delete Lawz for help, I can't say exactly what the plea deal would have been there in the Cherokee Nation, but if she were my client here in Salt Lake City, she would have I having seen the video, I would have told her, "Look, you must take the deal. There's no way you're being found innocent. We need to mitigate your harm, and that's going to involve negotiating the best plea deal possible." And that would have been about the same fine as she got, maybe less, because you know, 1,000, 1,500 really, because chances are the resisting and handgun charge would have been dropped. Plea to the DUI or the lesser intoxicated driving. Once again, that's here in Utah, um, which would have been 2 days in jail or 48 hours community service plus a fine plus license restrictions for a period of time. She'd already been done. She'd be done if she was a good girl. She'd be done with the probation by now because it's 2 days plus 6 months or a year probation, and that's based on first offense DUI. So that said, I'll see you tomorrow to talk about Floyd. And with that, thanks for joining me. Do all the YouTubey things on your way out, unless you do them on your way in. Like, share, subscribe. Have fun. I will see you tomorrow. Thanks for joining me. Bye bye.